Hello everyone. First I'm going to start with the cover letter. It's dated with today's date, July 27, 2017, via hand delivery to Mr. Bradley Stephen Harris, with his address listed here. Note, I only included Mr. Harris because he is our CEO and Cynthia Lind is the CFO, so Mr. Harris actually has a higher position, therefore I considered him to be the primary that this would be sent to. Attention Formation of Corporations, dear Mr. Harris, please find attached a copy of the proposed articles of incorporation, application for a certificate of authority, and corporate bylaws for the formation of Cutting Edge Computer Repair Incorporated. These documents have been drafted per your instructions. Please be advised that there is a $500 filing fee for the certificate of authority. The payment must be made to the Mississippi Secretary of State via cash, check, or money order. There's also a $100 filing fee for the Articles of Incorporation. That's supposed to be made out to the Tennessee Secretary of State via money order, cash, or check. And the documents require our client's signature before we can file them. As always, I remain truly yours, Belinda Murphy, Attorney at Law. This line is for the supervising attorney's signature. Down here, for those who do not know, these are side signatures, so BM is in all caps because that stands for Belinda Murphy, our supervising attorney, and also ZAT are my initials, and they're under lowercase because I am just the legal assistant / paralegal, so I'm not as important as Belinda Murphy, so I don't get capitalization. Anyway, our address and our company information is right here, Abrahams and Benson PLLC, with our address. Next, we have the Tennessee Articles of Incorporation. Now we have the filing fee right here. Also, the for-profit corporation charter sets forth items required under TCA 4812-102. And these are the instructions of how to fill out the Articles of Incorporation. Instructions continued. Now here is the actual form, and my computer would not let me edit the font or color or font size of any of this. So I understand that this doesn't look uniform and it bugs me, but I have no way to fix it currently without downloading special software that I don't have at the moment. Anyway, filing fee $100 as I stated. Note that the company needs to have the abbreviation Corp, Inc., or Co. So our corporate name is Cutting Edge Computer Repair Incorporated. Right there's the Inc. 2, name consent. If there was another company that had the same name as our company, then we would need to check that box, indicating that we have their consent to use the similar name. There is no company that has a name similar, so I can leave that box checked out. This company has the additional designation of blank because we have no additional designation, so therefore we can leave that blank. Name and complete address of the initial registered agent and offices located in Tennessee. Our registered agent is Bradley Stephen Harris, and his address is 123 Main Street, Memphis, Tennessee 38103 in Shelby County. The fiscal close month is going to be December, and our duration is perpetual. And we don't have a delayed effect date, so we can leave this blank as well. Our corporation is for profit. The number of shared stocks is 10,000. And the company address of its principal executive office is 123 Main Street, Memphis, Tennessee 38103, Shelby County. Now, submitter's information, Belinda Murphy, and here's her phone number. Next, the name repeated, and then the mailing address if it's different than the principal office. Since it's the same, we leave that blank as well. List of name of the incorporator, Bradley Harris, and Cynthia Lind with the same address. Professional corporation, since we left section 3 blank, this is section 3, the additional designation, we can leave this blank as well since it's not a true professional corporation, so we don't need a licensed profession number. Additional provisions, there are none. This information is all public record, and this is where our client will need to sign and date. For Mississippi, our application of certificate of authority, we have the email address of the corporation, for profit, name of the corporation. It is in Tennessee. We can leave this blank since we have no future effective date. Same address. Date of incorporation, today's date, is a perpetual corporation. For our registered agent, they are gonna hire Mississippi Registered Agent LLC, with this being that company's address, 270 Trace Colony Park Drive B, in Ridgeland, Mississippi 39157. Next, our officers. We have Stephen Bradley Harris, who is our CEO, Chief Executive Officer. Same address. Cynthia Lund is our Chief Financial Officer, with the same address. We don't have a third officer, so we can leave this blank. Our directors are Stephen Bradley Harris and Cynthia Lund, and I kept their titles as CEO and CFO. And we don't have a third director, so this can remain blank as well. The name elected to use in Mississippi, I decided to keep it the same as well, because if it's good enough for Tennessee, it's good enough for Mississippi, and our client will have to sign here. Next, our bylaws. I'm not going to read this word for word, or I'm going to try to avoid doing that. Instead, I'm going to try and surmise what these are exactly in the most concise way I possibly can. Article 1, the office, location. The principal office shall be located at 123 Main Street, Shelby County, and the board of directors shall have the power and authority to allow the corporation to conduct business in the states of Tennessee and Mississippi. The Mississippi Code is pursuant to 79-4-15.03 of 1972. Article 2, the shareholders meeting. The meeting place, all the shareholders meeting are going to be held at the registered office, which is 123 Main Street. And there must be notice of the meeting. Annual meeting time, they're going to occur on June 1st at 2 p.m. As long as that's not a legal holiday, and if it is a legal holiday, then it'll be the following day at the same hour. Special meetings of the stockholder for any purpose otherwise prescribed by statute may be called, and it called by the president at the request of the holders of not less than 4,000 of all the outstanding shares of the corporation. Now, I chose 4,000 because 4,000 is 40%. I know it's not 50%, but I still think 40% should be enough to convey a meeting if it's that much concern of the stockholders. Notice of meeting. All meetings shall have proper notice within a 10 to 50 day window. Notice must be given either personally or by mail at the direction of the president or board of directors. Closing of transfer books and fixing record date. For the purpose of determining shareholders' entities to notice of or to vote at any meeting, shareholders or any adjournment thereof, or entitled entities to receive payment of the dividend, the board of directors may provide that stock transfer book shall be closed for stated period not exceeding 30 days, nor less than 10 days, preceding such meeting. Proxies may vote, and their vote is valid for 12 months. Voting, no cumulative voting. Article 3, Board of Directors. General powers, the business and affairs corporation shall be managed by its board of directors. Number and tenure and qualification, there's going to be two directors on the board. Cynthia Harris and Bradley Harris and Cynthia Lund, and they're both residents of the state of Tennessee. Vacancies, all vacancies in the board, whether caused by resignation, death, or otherwise, may be filed by affirmative vote of a majority of the remaining directors. Now, I understand where this kind of gets into a problem, because we only have two board of directors, so if one gets removed, then obviously there can't be a majority because there's only going to be one vote. But honestly, of all the samples I kind of glanced at, they all require a majority vote. So I'm going to say if there's a vacancy, then it's still going to require a majority vote. It would just be a one person vote. Removal of the board. During a meeting, shareholders called for this express purpose, basically saying that if the shareholders would have to call a meeting with the express purpose of removing a director, any members of the board or the entire board can be removed from a majority vote of the shareholders. Meetings of the board of directors may be held without notice at the registered office of the corporation. Any special meeting of the Board of Directors may be held at any time. Notice of meeting, there must be notice, at least 2 days' notice. Loan, no loan shall be made to the corporation to the directors unless 2/3 of the shareholders vote to approve such action. Article 4, Officers, Designation. There's going to be a CEO and a CFO. Board of Directors will vote to designate these officers once a year. Now, our initial CEO is Bradley Harris, and this article explains his responsibilities and basically says he has the power to do as his office sees fit, perform all the duties that his office requires. Our initial CFO is Cynthia Lund, and this is basically the same language as the CEO, except in the event that the CEO becomes incapacitated, she would assume his responsibilities. A secretary shall issue notices for any meetings within the corporation. Secretary shall perform all duties that the position requires. Vacancies may arise. Board of Directors would have to set up a special meeting to appoint a new one. Removal, any officer can be removed from due to negligence or other reasons if he commits a crime. Requires a 2/3 majority vote. Salaries, all officers are entitled to a salary. Article 5, Contracts, Loans, Checks, Deposit. Contracts, Board of Directors may authorize any officer or agent to enter into a contract. Loans, no loan shall be issued. Checks, all checks will be have the name of the corporation signed by an officer or agent. Deposit, all funds will be deposited. Article 6, Stock. Stock certificates shall be issued in numerical sequence, and they must be signed by the CEO or CFO and must have the corporate seal. Transfer, the corporation shall maintain transfer of stock books. Maintain stock transfer books, and transfers shall be registered on such books. Article 7, Fiscal Year. The fiscal year will start on the first day of January and end at midnight on the 31st day of December. Dividends, issuing dividends. Board of Directors may declare dividends on its outstanding shares in the manner and the terms and conditions provided by law. Seal. The Board of Directors shall provide a corporate seal, which shall be circular in form and have inscribed the name of the corporation, and shall have corporate seal in the seal. And Article 10, the amendments, this basically says that the bylaws can be altered and amended or repealed, and new bylaws may be adopted. Adopted by resolution of the corporation's Board of Directors or incorporator on this 27th day of July 2017. Incorporated director requires his signature as well. So that is it. I hope that this will be satisfactory towards our clients and that they'll appreciate our work on this. Now, I will admit, as a side note, since I know this is part of the class and this isn't a real presentation, I do find it odd that our CEO and CFO are also our board of directors, but I guess for the purposes of this assignment, it's try to simplify it, but I would assume in real life that our board of directors and our officers would be different people, since the bylaws state that they vote on each other, and almost all samples of bylaws stated such things, so that's how I drafted those. But yeah, anyway, I'm tired. I'm sure everyone else is tired, so I'm going to go to sleep now. I hope everyone has a lovely weekend. Goodbye.